everybody, to Radcliffe Chambers Top Cases of 2024. I'm your host, Piers Digby, and I'm co-hosting with Olivia Wilson, who is one of our newest tenants here at Radcliffe Chambers. We will be doing a fairly broad and balanced practice mix with sort of a blend of insolvency cases and private client cases to hopefully keep everyone interested and engaged throughout. We hope to have a little time at the end for some questions, if you have any questions. But otherwise, we'll sort of leave that to the end and kick on for the time being. So without further ado, I will be passing over to Olivia from our first case, Kariva and Bedzimov.
Thank you, Piers. This is a top insolvency case of 2020 for me, not only because it's a Supreme Court decision, which tends to flag that there's something interesting at play potentially, because it's also an important judgment in the context of cross-border insolvency. So here we have a brief summary of the facts. Essentially, the respondent was a Russian citizen who was residing in England and had been since 2017. So the respondent's centre of main interest was in England, not in Russia. Then in 2018, the respondent was made bankrupt by a Russian court. And in 2021, the trustee in bankruptcy applied to the High Court in England for recognition of her position, but also for some assistance in realising real property owned by the respondent in London in Belgrave. It went to the High Court, it went to the Court of Appeal, and then it went to the Supreme Court. In the High Court, the bankruptcy order was recognised under common law, but no assistance could be given regarding the property. So this was appealed to the Court of Appeal. And again, the majority dismissed the appeal, but there was no provision which allowed for a foreign bankruptcy order to have effect on immovable property located in England. But Lord Justice Arnold dissented from that. So again, it was appealed and it landed in the Supreme Court. The trustee tried to submit that the English courts could grant relief at common law to assist a foreign trustee to get in and realise interests in land located in England. But the Supreme Court dismissed that and propounded what we call the immovables rule. So that at common law, no recognition will be given to any provision of foreign law or any order of a foreign court which purports to affect rights or interests in land located in England. And therefore, common law doesn't recognise the respondent's English property in London as being part of the assets that are within the scope of the Russian bankruptcy. And that was all outlined in paragraph 69 of the judgment. So I wanted to draw particular attention to paragraph 110 of the judgment, which I've popped up on the slide. The Supreme Court stated, it may be said with some justification that the application of the immovables rule in the case of a foreign bankruptcy produces a surprising result in leaving the bankrupt's immovable property in this country, so in England, to be enjoyed by the bankrupt, when actually in bankruptcy laws under both in England and the foreign states, in this case that was Russia, immovable property would form part of the bankrupt's estate. So sort of highlighting that it is, as they say, a slightly surprising result that the bankrupt could continue to enjoy his property in London. But there were reasons, obviously, why the Supreme Court came to that conclusion. And this was in part due to a policy reason. So it's for the Parliament, not for the courts, to determine whether, and if so, under what conditions, there should be further development in the legislation, because at the moment, the Supreme Court decided that there was no legislation that could assist in this particular case. So this was an important reminder of the separation between legislature and the judicial functions in the UK. The Supreme Court was clear also that the common law powers of assistance did not allow for assistance that is inconsistent with substantive law, and they decided that the immovables rule was one of substantive law. Pursuant to the cross-border insolvency regulations 2006, it was also noted in their judgment that it had been open for the respondent's creditors to apply for a bankruptcy in this country, given the fact that the respondent had a centre of main interest and domicile for bankruptcy purposes in England. So this was an interesting sort of point that, and a reminder, I suppose, of the role of COMI and also generally that creditors should really consider in which jurisdiction they initiate insolvency proceedings. So that's another consideration to have. Although not relevant for this particular case, because Russia isn't classed as a relevant country for this provision, but also a reminder to think about Section 426 of the Insolvency Act 1986 and whether that can be of any assistance when dealing with cross-border insolvency. So that provision, Section 4, states that the courts having jurisdiction in relation to insolvency law in any part of the United Kingdom shall assist the courts having corresponding jurisdiction in any other part of the United Kingdom or any relevant country or territory. So that wasn't available to the trustee in this particular case, but something to bear in mind when dealing with cross-border. So that is my first top case, 2024.
Second up, we have Hirachand and Hirachand, and a sneaky bit of cross-advertising here because this featured Radcliffe Chambers' very own Sophia Rogers as one of the juniors in this case. It's been very interesting seeing this one progress itself all the way up to the Supreme Court and an interesting outcome, certainly, that leaves a lot to think about. So the background, for those of you that aren't familiar, we have the Inheritance Provision for Family Independence Act 1975, and that provides that certain categories of people can apply to the court if a deceased estate fails to make a reasonable financial provision for them. And the usual categories of people are spouses, children, dependents, and so on, people that there might be some kind of responsibility towards. Now, the court has a fairly wide discretion in considering orders to make under the Inheritance Act. And there is a list of things which it should regard that are set out in Section 3. The first of those, at 3A, is the financial resources and financial needs which the applicant has or is likely to have in the foreseeable future. Now, a key part of Inheritance Act claims is that they are often brought by claimants who aren't particularly well off. And the reason for that is because if they were well off, it's unlikely that much provision would need to be made for them. This means that claimants run into the usual problems that are associated with being from a poorer background, which is the difficulty in funding the litigation itself. So as practitioners in this area will know, it's very common for these sorts of claims to happen on a conditional fee basis. Unfortunately, this runs into a slight problem because the Courts and Legal Services Act 1990, by Section 58A6, provides that a cost order and proceedings may not provide for the recovery of a success fee. Now, this can be a real obstacle in these sorts of claims because the success fee in a CFA can often be quite significant. And so if you're a claimant who receives a moderate or would receive a moderate amount of compensation, you'll find that can be very rapidly eaten away by a success fee and really make it so that your claim can be not particularly worthwhile. Now, one way that there has been of getting around this is to say that maintenance, when the courts examine it, is not to be dealt with too prescriptively. And this was the line that the Court of Appeal took in Hirachand. It's well established that the payment of debts can form a legitimate part of the maintenance award, and you can see that in Ray Dennis. So if the payment of debts can be a part of maintenance, because otherwise the monies that are awarded would be eaten away so that there isn't reasonable provision at all, surely the payment of costs ought to fall in that. Otherwise, what's the point of these claims? They're not adequately putting claimants at the point where their maintenance is provided for. And so there's certainly a logic to that. This then reached the Supreme Court on appeal again. And the Supreme Court very much went back onto a first principles basis. And that is to note that costs are ordinarily only recoverable as costs, even though in many sorts of claim, you could think of other ways of categorizing them. So if you think of, for example, a breach of contract claim, well, the legal costs in that, they are a foreseeable consequence of the breach of contract. Right? If the other party breaches their contract, they can likely see that you're going to have to incur legal costs in order to litigate against them for that breach of contract. Nevertheless, you can't recover the legal costs under the contractual head. You have to recover them by means of going after them as costs. Secondly, there was a very clear parliamentary background in wanting to prevent success fees imposing an excessive burden on justice. There's a range of reports that were produced around the time looking at the basis for this. And so in particular, there's Sir Rupert Jackson's review of civil litigation costs, which remarked that litigants with CFAs had little interest in controlling the costs incurred on their behalf, and that the resulting costs burden on the other side was excessive and amounted to denial of justice. And this led to the legislation in 2009, which made success fees irrecoverable. When you put those two things together, it seems that the clear intent was to prevent success fees being recovered under any background, rather than there being a backdoor route. And the fact that this was a backdoor route could clearly be recognised by the fact that you didn't see any judgments where the irrecoverable part of the base fee, so that the part was disproportionate or unreasonable, you never saw that being awarded in the court's orders for provision, despite the fact that in many respects, the key problems are the same. You get an award for your maintenance, it needs to be a certain amount. And if you're losing amounts that you're having to pay for costs, it might put you below that amount. So these things should have been treated the same. They weren't. And the Supreme Court opted to make things uniform and effectively say, no, we need to be consistent. We need to say you're not going to be able to recover success fees by way of provision. So what are the practical consequences to this? Well, the first is that this introduces a real barrier to a lot of claimants for inheritance tax claims. As I noted at the start, that the nature of these claims means that it's very common for them to be brought on a CFA basis. The level of financial provision that is needed can often be for what are, in the grand scheme of litigation, relatively small amounts, but for these claimants, that can represent very large sums to them. Unfortunately, the success fees can eat away at that so much as to often leave them feeling like it's not really worth them trying to pursue their rights. If the issue is parliamentary intent, then perhaps this is an issue where Parliament might want to reconsider its position. There's surely an advantage in people being able to have provision made for them where they need it, without that, for example, having to come from the state. It'd be a lot better if people could go after the wills of those who are responsible for them, rather than having to seek it from other sources. So perhaps there's a question about whether something like legal aid might be considerable for the most worthy claimants. But for the time being, it does look like we might start to see a reduction in the level of these claims being brought. Finally, any advice on merits now requires extra careful scrutiny of the position after costs. Is it really going to be worth going for these claims after you have looked to the success fee? I think that's a question that we need to be asking with ever more care. So that was our second case, Hirachand and Hirachand.
We've got another private client one for you. And this time it's Leonard and Leonard, which covered the topic of testamentary capacity regarding will challenges, and in which Radcliffe's Thomas Dumont KC and Ed Hicks both appeared. So we start off with a family tree to show the people at play. So J is Jack, our deceased, that you can see in the middle there. And then A is Audrey, that was his first wife, and they had 4 children. His wife predeceased him, and so her estate went to the deceased. The deceased then remarried, demonstrated by that straight line, to Margaret, who was M on my family tree. She had had 3 children with a previous marriage, although one of her children had sadly predeceased her, leaving 3 grandchildren, which I'll describe as Margaret's family, to make things a bit simpler. So predictably, this dispute was over two wills. So the first was the 2007 will, where the deceased had decided to divide up the residual estate in 5 equal shares. So that was between his 4 children and then to Margaret. And he then made a 2015 will, which included a life interest in the residual estate for Margaret and then subsequent division to his children and Margaret's family. And so instead of dividing by 5 equal shares, the 2015 will divided by 7. So this matter came before the High Court, and it was concluded that the deceased did not have testamentary capacity to execute the 2015 will. So the 2015 will was set aside in favour of the 2007 will. So Leonard and Leonard confirmed the Banks and Goodfellow test, which I'm sure many of you will be familiar with, but I've just popped it up on the slide there for ease. This was a top case for me because the judgment gives a really comprehensive analysis of these 4 limbs and provides some quite clear authority on how the court will approach the Banks and Goodfellow test. And so it's essentially just a useful reference to revisit for us practitioners. In particular, the judge gave some needed clarification on the first and the 4th limb up on the screen. So the judge stated that in the first limb, this doesn't mean the ability to understand a hypothetical will, but instead require the deceased to understand the nature of the will that they were making, so that particular will. And then regarding the 4th limb, the judge concluded that dementia could fall within this 4th will, 4th limb, so a disorder of the mind, as opposed to leaving that to be predominantly used in sort of for short episodes of, for example, psychosis. And that was all outlined at paragraph 477 of the judgment. In this case, there were also 2 expert witnesses, but neither of whom had examined the deceased during his lifetime. So this case is quite a good reminder of actually the limitations of expert evidence. And that was expressly stated by the judge at paragraph 138 of the judgment, which stated, ultimately, it is for the court and not an expert witness to determine what, if any, inferences should be drawn from the documentary and other evidence when seen in its proper context. So that gives a bit of a warning that while helpful or often helpful, it doesn't necessarily mean that expert evidence will get you across the line. And the applicability of Leonard and Leonard is also one of the reasons for it being a top case. I'm sure many of you know the frequency in which discussions surrounding testamentary capacity arise in disputes over wills, and therefore this can be very useful to refer back to, and also what is required when taking instructions in the execution of a will. Now, I will touch very briefly on the cost side, just because it's quite unusual. And it was unusual, firstly, because the court made an issue-based cost order due to the third claimant conceding her claim regarding some lifetime gifts. I won't go into this in any depth, but paragraphs 82 to 86 of the judgment make clear why it was appropriate in this case. But essentially, overall, a percentage-based order wouldn't have done justice to the parties, in particular because there was a lack of evidence to determine an appropriate split between the probate dispute and the gifts dispute. Secondly, it was unusual because the court applied an exception to the general rule that costs follow or the unsuccessful party pays. The judge stated that in probate cases, it's necessary to consider whether the court should be guided in exercise of discretion in common law exceptions. And the exceptions allow good cause to be shown why costs should not follow the event and require the court to ask, firstly, whether the litigation was caused by the testator or beneficiary, in which case it might be appropriate that the estate pays. And secondly, whether, and this is the one that was relevant in this case, whether the circumstances, including the knowledge and means of knowledge of the opposing party, led reasonably to an investigation of the matter, and if so, the court may make no order as to costs. The judge found that it was reasonable for the defendants to have investigated this matter, and as such, parties were ordered to bear their own costs up to and including the mediation. And this was despite the fact that indemnity costs were at play due to the claimant's Part 36 offer. So I hasten to add that the probate exceptions are exceptions, but this was a good demonstration of where one of them succeeded. And then finally on the cost point, ending on a bit of a warning, the judge also made an order that any party who wished to join the firm who was responsible for drafting the will could be joined for the purpose of seeking a non-party costs order. Overall, to me, London Leonard is a useful case for practitioners to be able to refer back to, and gives an example of a bit of an unusual costs order.
Thank you. So next up in number 4, we have Nilsson and Kinberg. This is an interesting one because it clarifies a situation that there's been some doubt about, and in a way that perhaps some practitioners in the field didn't necessarily expect. So what's it about? It is another case of cohabiting couples, and the usual problem about what happens when those couples break up and they have to disentangle their relationship and the status of the various property that they owned. I'm sure we'll be familiar with it, but it always helps as a reminder that the starting position is that in Goodman and Gallant, where there is an express declaration of trust over the property. This determines the true nature of the equitable division of the property, overriding any prior common intention, constructive trust or equity. It's no good saying we understood it was this if there's a piece of writing that says it was that. However, this has been subject to the caveat, as set out in Stock and Dowden, that an express declaration of trust can be varied by subsequent agreement or affected by proprietary estoppel. And that, on face, makes a lot of sense. If you have an express declaration that seems to bind all of the parties, but then later on the parties sit down and put in writing, actually, no, we want to vary it to this, it makes good sense to allow them to be able to do so. The question that arises are, what are the requirements of any subsequent agreement? Now, perhaps one conventional view was informed by remarks in Pankania and Chandegra, which was discussed extensively in Nilsson and Kinberg, and in particular, part of the closing paragraphs of the judgments, where it provides that reliance on Stack and Dowden, Jones and Curnow for inferring or imputing a different trust in this and other similar cases is misplaced where there is an express declaration of trust of the beneficial title and no valid legal grounds for going behind it. So we've got our express declaration, there's no room for your common intention, you're going to need another express declaration, is the way that a lot of people read this. And in particular, the Law of Property Miscellaneous Provisions Act obviously provides for the formalities for the disposal of equitable interests in land. Now, here, we did have some quite unusual facts that perhaps explain part of the later parts of this judgment. So you have a husband and wife who acquired property in 2001 with a deed of transfer recording them as joint tenants. So far, so usual. They split somewhat amicably in 2009, and it was agreed between them that the wife was to receive the property. From the point of that agreement, she took on all of the maintenance and upkeep of the house, be that the mortgage, repairs, and she put her own monies into home improvements and so on. But importantly, no formal transfer ever took place. The divorce proceedings weren't finalised for another decade. So on paper, at least, the deed of transfer from 2001 remained in effect, and it still looks like it's a joint tenancy situation. In 2018, the husband becomes bankrupt. The trustees in bankruptcy get into office and decide to go after his share of the property. At this point, the wife claims that the express declaration was varied by subsequent common intention constructive trust or proprietary estoppel. So there was an understanding that she had with her husband, or by now ex-husband, that she had relied on that understanding. It had been to her detriment, and it would be inequitable for him, or in this case for his trustees in his place, to go back on that. What makes this a little unusual at this point is that the husband is not a party to this per se. It's obviously the trustees and bankruptcy that are pursuing this. But because the split was on, by this stage, a relatively amicable basis, he is supportive of her claim. He comes forward and says as a witness, yes, this was our agreement. I understood she was to take on all of these things, and she did in fact take on all of these things. So the way the decision went was to say that, look, stacking down, it's very clear that an express declaration of trust can be modified by an agreement. So this isn't overruled by Pancania, and what practitioners have been doing is reading parts of Pancania excessively narrowly. So properly understood, Pancania simply applied to a situation where the common intention trust was arising at the same time. So you've got your common intention on the one hand, you've got your express declaration on the other hand. They're on a level with each other. Express declaration wins. This was not the case here, where it is clear that the common intention constructive trust very definitely arose subsequently. Now, no prior judgments in the court's view had explicitly stated that variations needed to comply with the statutory provisions. So it wasn't as simple as just pointing to a case and saying, look, it doesn't also need to be done expressly. But Stack and Dowden, if you remember, mentioned that it could be overridden by subsequent agreement or proprietary estoppel. And there are a long series of cases in which proprietary estoppels have been found to apply, where the promises made in respect of the property had not been in written form. On this basis, it would have been inconsistent to say that the same couldn't be true of common intention constructive trusts, because why would one form of equity be subject to this restriction, but not another? So Nielsen and Kimber confirmed that no, you don't necessarily need an express declaration to vary the prior express declaration. You can just have an understanding sufficient to give rise to a common intention constructive trust. What are the consequences of this? Well, one view of this has been to say, well, this is great. We can bring all sorts of claims now whenever you have cohabitees who split up, because even if there's an express declaration of trust, well, as long as one side can say, well, I thought the situation was this, and I'm pretty sure the other side agreed, you have sort of the foundations of a claim for a common intention constructive trust. And so from that perspective, the decision initially looks like it might throw the doors open. My view is that that's not correct, and we need to be more careful than that. The facts here are very narrow, because this is a rare situation where the couple actually agree, and the party prosecuting it is the trustee in bankruptcy. Where you have couples who don't agree, meeting the evidential level to show that there was a subsequent common intention constructive trust that could vary an express declaration, my view is that's going to stay quite hard. Now, the real secret danger here, and this is where this case perhaps transforms from a private client case into an insolvency case, is the danger to trustees in bankruptcy. If you are coming into office as a trustee, there's a real problem of how do you know whether there has been a common intention constructive trust arising before? When it's litigation between the two cohabitees, well, they were the parties to that understanding. That they'll have known about the understanding, whether it existed or didn't exist, because they were actually there participating in the events that did or didn't give rise to the understanding. And the trustee, that's a lot more difficult for them. And it does raise the prospect that couples splitting on amicable terms could take steps effectively to defeat trustees in bankruptcy by saying, well, look, we had this understanding. You can't go after my ex-husband's share. And particularly where perhaps the split is amicable and there's children involved, there's going to be a real motivation to do that, but that trustees have to be careful of. The thing to look out for that can help is in Nielsen and Kinberg, one of the big factors that led the court to conclude that there was either a common intention constructive trust or proprietary estoppel was the very significant financial contribution by the wife. And so it's going to need trustees in bankruptcy to have a real careful look into the background of the case when common intention constructive trusts are alleged, and see exactly how much the parties were contributing over the relevant time. If you're noticing that one really is putting in a lot more than the other, that might be an early red flag to perhaps consider their claim has a bit of merit to it. So because of that, that is our fourth top case for 2024.
So moving over to Sham Participation Corporation liquidation and Halimeda International Limited. So this is a Privy Council decision in which Radcliffe James Morgan KC appeared. So this case contributes to the discussion of whether an arbitration clause in an agreement should prevent a party from being able to seek to wind up for an unpaid debt arising out of that agreement. So the Privy Council was considering an appeal from the Court of Appeal of the Eastern Caribbean Supreme Court, so it's originating from the courts of the BVI. So the Privy Council ruled that the correct test for the court to apply when exercising its discretion whether to make an order for the winding up of a company, where the debt on which the petition is based was subject to a generally worded arbitration agreement clause, was whether the debt was disputed on genuine and substantial grounds. And the Privy Council kind of gave three main reasons, as I see it, as to why. So firstly, it would be contrary to the objective of efficiency to require the creditor to go through the arbitration when there was no genuine or substantial dispute to stop a liquidation. And so all that's happening is adding some delay, trouble, expense for no real good purpose. Secondly, the objectives of party autonomy were not offended because seeking a winding up or liquidation was not something that the creditor had ever promised not to do. And then thirdly, the objective of non-interference by the courts was also not offended, since ordering a liquidation of the court was actually not resolving anything about the debt itself, and so wasn't interfering with the resolution of any dispute about the debt. And so this was interesting because it overruled some English law authority, which is the Salford Estates case, which is up on the slide. That provided authority that the arbitration clause should usually take precedence and winding up proceedings should generally be stayed unless there was some sort of exceptional circumstances going on or other reason. The Salford Estates method of thinking is now no longer to be adopted, as the Privy Council made what's called a Willers and Joyce direction, and that it should no longer be followed in England and Wales. And they stated at paragraph 125 that they thought that Salford Estates had been wrongly decided. So the conclusion of that is that now the law in England and Wales is aligned with the position in the BVI. And as the Privy Council made clear in the first paragraph of the judgment, this is really about balancing and finding this line between two areas of public policy. And that's something that I found quite interesting. So there's the public interest that there should be sort of a simple and efficient means to place an insolvent company into an insolvent process without undue delay. But balanced with that, the public interest that parties to a contract where they've agreed to resolve a dispute by arbitration should do so without court interference. After the Privy Council decision, a Hong Kong first instance court considered the same issue and came down on the side of the Salford Estates method of thinking, and so departed or didn't follow the Privy Council case. So this is an area to me that seems to be developing, and therefore sort of a top case in my books. And I'll certainly be keeping an eye out to see what route other jurisdictions take, and whether there's potential for a more unified approach across different jurisdictions.
Thank you. And here we come up to the sixth case, Rare Company, BHM 000012. This one, you wouldn't possibly think that a matter on face this simple could end up in the Court of Appeal, but here we are. This is a case about when exactly it is a winding up petition is considered presented. And this is something that is going to be extremely important to our junior insolvency practitioners. we've been asked a question. I'm answering most of those at the end, but we've just been asked whether slides will be circulated afterwards. Yes, I can confirm slides will be circulated afterwards. I have here, hopefully, a helpful little diagram to set out the sequence of events. On the left, it shows you what the respondent company was doing in the business and property courts in Birmingham. And on the right, it shows you what the petitioner was doing in the business and property courts in Manchester, because we had two sort of streams of application not in sync with each other, which was causing problems. So the petitioner, or future petitioner at that point, put forward a statutory demand on the 13th of December 2023. The company receiving it obviously decided, well, we don't fancy a petition being presented against us. Let's get an application for an injunction to restrain the presentation. And they put that in on C file with the court on the 3rd of January 2024. On the 5th of January 2024, that application to restrain was accepted for filing. Meanwhile, come the 12th of January 2024, in Manchester, the petitioner's solicitors put on the C file, submitted on the C file electronic system, the winding up petition. On the 14th of January 2024, they had a response from the Manchester court staff who told them, paraphrasing, but this part reasonably important, that the notified petition had been filed, and what was now needed was simply the deposit. On the 15th of January 2024, the Birmingham court sent out the application to the parties, and that same day, the petitioner had sent over a cheque to Manchester. On the 17th of January 2024, the petitioner received the application to restrain the presentation and immediately called up the other side and said, look, you're too late. We've already filed our petition. It is presented. Away we go. On the 17th of January 2024, the company called up Manchester and was informed that the petition had been filed but had not yet been issued because the deposit was needed. So the company wrote to a judge at the Birmingham court and said, can we get an order that is preventing the petition from being issued, even though it has been filed? They obtained that order, but it's sent over to Manchester too late in a real comedy of errors, and the Manchester court issues the petition. Reluctantly, the Birmingham judge just has to throw up his hands in the air at this point and say, well, look, I'm going to have to dismiss the application because the petition is out there in the wild. The company appeals this. They say that no, the petition should not be considered presented until the deposit is provided, and the cheque would not have been received until some point after the 15th of January when the cheque was sent. So we end up with our incredibly simple question: when is a petition considered filed? So a historical deep dive, right, was the way the court started, and I went back to the old 1986 insolvency rules, and there the equivalent rule to the modern ones read, no petition shall be filed unless there is produced on presentation of the petition a receipt for the deposit payable on presentation. So here we can see that the deposit payable on presentation is a prior and necessary condition to the petition being filed. No petition shall be filed. The current Insolvency England and Wales Rules 2016 provide that the petition must be filed with the court, and a petition may not be filed unless a receipt for the deposit payable to the official receiver is produced on presentation of the petition. But now you see that filed and presentation are being used as two separate things there. So conceivably, you could say, well, we have filed it, and we will produce a deposit on presentation, but it's still filed before that point. And that was the petitioner's argument. Finally, we have the insolvency proceedings practice direction, which says that a winding up petition shall not be treated as having been presented until the court fee and the official receiver's deposit have been paid. but this says treated. So surely, again, the petitioner's argument, the petition is presented when it's put into filing. You just don't treat it as presented up until the deposit is received. But it is presented, and effectively the presentation of the deposit has almost sort of retroactive effect. It confirms that it was presented all along. What did the Court of Appeal decide? Well, the Court of Appeal decided that the language was a little confusing, and that the 1986 rules were really the best guide to this. Filing is an act of the court. You submit something on CE file, but the actual act of filing is the court opening up a file on the thing so that it can be available for inspection. Strictly speaking, petitioners deliver after filing. Filing happens and presentation occurs when payment is made, or when the cheque is received, because otherwise you could have a situation where a petitioner delivers up the documents by sticking in the petition on the CE file, then just doesn't pay the official receiver, sits on the petition the whole time, but safeguards the presentation date. This would be a very undesirable situation, because it leads to presentation dates that were well before when the petition actually starts progressing in the courts. What's the practical lesson from this? One, a very simple lesson: pay as quickly as you can. You want that earlier presentation date because you want the protections up there, the stay of the proceedings and the avoidance of property dispositions and so on. So in that case, where you can, make payment by card over the telephone, the official receiver. Checks are probably just too slow in this modern world. If you're relying on an early submission to CE file, it's not necessarily going to be enough. So a very important practical lesson, and that's why that is one of our cases for 2024.
So moving back to the realm of private client, rare and rare. In this case, Anna was our deceased. She made a will in 1986, leaving the estates to her 4 children. She had a daughter called Rita, and then she had 3 sons, and she'd had left it to the 4 of them in equal shares. But she made a new will in December 2015, and she gave her home, which was the sole asset of value, to Rita, and then the residue would be shared between the 4 children. And there was an express statement in the will that her sons had not helped her with her care, and that if they challenged the will, then Rita was to resist such claim, as Rita was the executor. Also relevant is that her sons were not told about the will during her lifetime. So Deputy Master found that the will was valid in the High Court, but then the sons appealed on the basis that the Deputy Master had restricted their cross-examination of Rita. The Court of Appeal allowed an appeal and ordered a retrial, and that's why we have a retrial of the matter. And then in that retrial, the High Court decided that the will was invalid by reason of undue influence. And so Rita appealed. So to me, similarly, how Leonard and Leonard sort of provides a reference tool for practitioners for testamentary capacity, Rare and Rare in my mind provides the same type of reference point for undue influence claims. The court helpfully laid out that there's a high bar for successful undue influence claims, and stated that in most cases, undue influence is inherently improbable, and also confirmed things such as, persuasion is perfectly legitimate, provided it's not coercion. So this helps to guide practitioners when advising clients and setting realistic expectations over sort of what's likely to get across the line and what isn't. In a similar vein, the Court of Appeal considered arguments that are commonplace amongst undue influence claims, and has now provided some analysis on the strength of those, in particular, rejecting some of the common arguments that I've put on the slide. So the fact that the testator was frail, the fact that the defendant had a strong personality. In fact, as I put up there, paragraph 46, they said people with forceful personalities do not routinely, let alone invariably, exercise undue influence. Other common arguments are that the defendant was involved in the making of the appointment for the will, that the will was kept secret, as was in this case, and again, that persuasion can be perfectly legitimate. So it's very useful for practitioners to be able to sort of look back and see how the Court of Appeal dealt with those quite common arguments that we see raised. I've also put up there evidence from the solicitor and Anna's doctor. So in this case, the Court of Appeal states at paragraph 55 of the judgment that one of the problems with the reasons that the judge had given for finding undue influence at the High Court level was that they felt that he hadn't taken sufficient account of the evidence of the solicitor who took the instructions of the preparation for the 2015 will and Anna's doctor, both of whom the High Court judge had accepted to be reliable witnesses. Therefore, the Court of Appeal felt like there should have been greater account for that evidence that was given. And then finally, sort of a point of interest in this case is that, as you will all be aware, often advice needs to be given to clients about litigation risk. And this case is a good example where and why those warnings are important, because different trial judges arrived at different conclusions on the same issues. And so I thought that's a point to take away.
I will say, as a very minor footnote for Radcliffe Chambers junior practitioner regulars, that you may remember the original Rarely Rare was on our list of interesting cases for the previous year. So it's good to see it pop up again. And it's also good that our observations that some might have found the original case controversial were indeed backed up. So who knows which of this year's cases we'll see again next year. Right, on to White and Chappell, and possibly controversial, but this would be my pick for the #1 case of the year. So we're saving the best till towards the end. So White and Chappell, this is an insolvency case. The background situation: the defendants are the directors of 4 companies in the BHS group in the 2 years prior to those various companies entering liquidation. There had been a previous successful trial against them, the details of which don't need to concern anyone too much, but effectively found they'd committed various breaches of duty and also engaged in wrongful trading. But one issue had been adjourned for further consideration, and that was the issue of quantum for what in the original trial was called the sequana duty. Now, in flashback time to another Radcliffe Chambers top case of the year from 3 years back now, 2 years back, BTI 2014 LLC and sequana, perhaps one of the most significant cases of the last 5 to 10 years, where the Supreme Court considered the nature of the duty owed by directors to creditors. Now, the judgment was a very long one, and it wasn't a unanimous one. So piecing out what exactly the sequana duty is perhaps still has to be elaborated further by further court cases. But generally, the Supreme Court concluded that the duty of directors towards creditors is not really a standalone duty, but is better understood as an extension of the director's duty that they owe to the company. It arises when it is probable that a company will enter into insolvency, something more than real risk. And it's not necessarily a sliding scale. It appears to be something closer to a tipping point. When that tipping point is engaged, then the directors need to make sure that they're giving appropriate consideration to the interests of the creditors. So that's the sequana duty. What's interesting is that despite this being called the sequana duty, on the facts of sequana, there was no sequana duty. It didn't arise to the directors in that case. So the issue of quantum, what sort of compensation needs to be paid out for someone who breaches this duty, wasn't considered. Therefore, this is the sort of first milestone case in assessing what that is. The liquidators have 3 basic contentions. First is that this is a but-for test when assessing the need for compensation. You don't need to look at the foresight or remoteness. You just need to say, as a result of the breaches, this has been the loss. They said that the nature of the loss is the loss in the net assets available on insolvency. because if you think about it, that's what the creditors are interested in. It's not necessarily like a wrongful trading issue where you're concerned with what was or wasn't traded. You're concerned with what the creditors have at the end of the process in order to protect themselves and to realise from insolvency. And finally, they said that the liability ought to be joint and several. The directors contended that any individual quantum of compensation needed to be attributable to a specific breach. So you had to say, this is the director, this is the specific thing he did wrong, this is the consequence that follows from that specific thing, and identify a particular item of loss rather than just a loss in net assets available. And secondly, that in any event, the court had the discretion to apportion liability rather than opt for joint and several. So that they didn't contest that the starting principle was joint and several, but they said, look, the court can move away from this. The decision, a first principles approach, and something that's always good to be reminded of. The court went back and looked at what the nature of equitable compensation is. And the trouble is that the term equitable compensation is itself slightly misleading. The remedy is restitutionary or restorative. What it aims to do is put back into the fund the monies that were taken out of it, and not restore the fund where it would have been but for the breach. So sometimes the fund can end up better off than it would have been but for the breach, because, for example, perhaps the fund might have diminished in the interim, but the funds that are taken out were preserved. Well, here, the compensation would actually deliver more than, for example, compensation in contractual claim. This equitable principle applied to directors of companies in respect of company assets just as much as trustees in respect of the trust funds. It's the basic principle of how these equitable claims work. In respect of the connection between the breach of duty and the loss, the court opted for a middle ground option between the two sides. It's not enough to simply say a breach of duty has happened, the assets have gone down, therefore the value of the assets should be restored. There was a need to show a link between the breaches of duty generally and the diminishing of the value of the assets, but not necessarily so much as showing a very particular breach to be linked to a very particular depreciation, simply that there was an effective cause, not necessarily the sole cause, but an effective cause between the breaches of duty and the depreciation of the value of the assets. To give an example of the difference between those, suppose as a result of wrongful trading, although a particular piece of wrongful trading might have been for quite a small amount, it might give, say, business confidence to partners of the company. That means the company goes on trading for a lot longer and therefore diminishes its assets much more by the time the insolvency process actually kicks in. So that the small amount involved in wrongful trading can often be dwarfed by the losses caused by the company rumbling on much longer. So we can see the distinction between those. One last canny argument that the directors tried to get around this was to say that, well, look, if you look at section 214 of the Insolvency Act, which does deal with wrongful trading, despite the fact this will often be for a lesser remedy, it requires that the person knew or ought to have concluded that there was no reasonable prospect the company would avoid going into insolvent liquidation. Now, that knowledge bar is quite hard to meet. So how can a lesser remedy require a higher bar? All that will happen if the court allows this is a flood, the floodgates being opened and a huge number of Section 212 applications being brought. The court rejected that. They said that sometimes your Section 212, your misfeasance, that's going to be necessary to get a proper scale of remedy. So the consequences. Firstly, great news for liquidators. This means that the scope of recovery can be enormous. Secondly, notwithstanding the judge's comment that Section 212 and Section 214 both had relevance, Section 212 of the Insolvency Act is just very appealing because it allows you to go through the faster Insolvency Act process instead of making a Part 7 claim, but without the high bar of knowledge required in wrongful trading. So you've got a best of both worlds approach. And equally, both of those 2 points, if they're great news for liquidators, they're very bad news for directors. And in particular, if the scope of recovery for equitable compensation is this wide, that might seem sort of appropriate for cases where there was intentional breach, but this now raises a question about negligent breach of trust in particular. It'd be interesting to see how cases on this acquired duty deal with this going forward.
Okay, so on to Manolete Partners PLC and White. This is a top case of mine. However, I will disclose that there might be a bit of personal bias because I had the opportunity to shadow Radcliffe's Ruben Kaminsky, who was led in the Court of Appeal in this matter, acting pro bono. And I also got to contribute to the supplemental note that went before the Court of Appeal. But aside from that, it is generally an interesting case about whether an occupational pension can be accessed by creditors. So these are the facts. Manolete obtained a judgment against Mr. White for breach of director's duties, and that judgment remained unpaid. Mr. White had an occupational pension, but it was not in payment. Manolete applied to the High Court for an injunction to force Mr. White, the defendant, to draw down his pension to satisfy some of the judgment debt. And the High Court ordered Mr. White to draw down it, and so Mr. White appealed. There was no good stock image for a pension, so an old-fashioned piggyback will have to do. So it went to the Court of Appeal, and the Court of Appeal found that Mr. White could not be ordered to draw down his occupational pension to make it available for Manolete for enforcement purposes. So a lot of this case revolved around Section 91, subsection 2 of the Pensions Act 1995, which I've popped on the screen. And so that section covers the inalienability of an occupational pension, and it prohibits the court from making an order, the effect of which would be that a person would be restrained from receiving their occupational pension. So this is a protection that statute affords occupational pensions. The High Court had reconciled this statutory provision with Manolete seeking access to the pension by ordering Mr. White to exercise his right to draw down into his own bank account first, and then had to notify Manolete. So once the pension had been received by Mr. White, Manolete knew and then could initiate enforcement proceedings. The Court of Appeal decided that this two-step process breached the statutory protection afforded by Section 91, subsection 2, that the order requiring the drawdown couldn't be separated from the ultimate objective, which was obviously to enforce against it. The reality of the situation was that the defendant couldn't be said to be receiving his pension, and therefore the statutory prohibition would be breached. It was no use to try to curate the order so that Mr. White received funds into his own account, because as soon as he did, he would have been obliged to notify Manolete, and then they would have ensured that it would get paid on to them. And paragraph 64 of the judgment comments specifically that Section 91 uses the words, the effect of which would be that he would be restrained from receiving the pension. So this case was in my top sort of cases of 2024 because it enforced the protections that pension rights can have against creditors, but was also a reminder where there might be some exceptions which could be considered by creditors and trustees. So one point of interest was that the judgment makes very clear that it's not just inconvenient to construct an order for the purpose of circumventing a statutory prohibition. So there's no point saying, oh, okay, well, we'll get around it by him receiving the money into his own bank account first. And another point of interest for me is that while this case enforced the protection of Section 91(2), there are exceptions, particularly in Section 91, subsection 5, and then clause D. So that's an exception which would have allowed, if it was relevant, a charge against Mr. White's pension rights had the debt arisen out of Mr. White committing some kind of negligence or fraud. So the position is different if there's fraud at play. Manolete had tried to file a late respondent's notice relying on this provision, arguing that the underlying judgment against Mr. White, which was breach of fiduciary duties, arose out of a negligent or fraudulent act. The Court of Appeal refused to allow Manolets late notice, but did make a comment that it was, and I quote, far from obvious that a liability for breach of fiduciary duty fell within the terms of negligence or fraud for section 91(5) subsection D. I'll also note that section 91 doesn't preclude an income payment order or an attachment of earnings order if the pension is being drawn, which it wasn't in this case. This is something I've been asked about before, so I think it's worth just stating that if the defendant has been drawing his pension from a registered pension scheme, then creditors, trustees could have sought an income payment order and attachment of earnings orders. And then also just a final point is particular to trustees in bankruptcy. If excessive contributions are being made to a bankrupt's pension scheme, a trustee in bankruptcy can claim the pension rights from the excessive contributions under section 342A to 342C of the Insolvency Act 1986. So this was a top case for me because it enforced the protections, but it also is a reminder to the exceptions or where creditors might be able to look towards the pension.
Last one, and I'm aware we're running a little over time now, so I'll be through this one fairly briefly because it's interesting, but perhaps factually a little simpler, which helps. So Rahman and Hassan. This is perhaps that most soap opera of legal claims, the DMC, the deathbed donation, or to give it its fancy Latin title, the Donatio Mortis Causa. These are testamentary dispositions which take place on death, which have the rare privilege of not needing to comply with the formalities of the Wills Act 1837. So the sort of stereotypical situation is you're on the deathbed, tremulously reaching out. You place the ring in your son or daughter's hand and say, "This is to be yours," or words to that effect. That's the sort of iconic case of it. And in those situations, the law will recognise that gift. These are testamentary dispositions, so the gift takes effect on death and can be revoked until that takes place. And there are various sort of protections that have evolved because the formalities in the Wills Act exist for a reason, effectively, to protect the estates of those making testamentary dispositions, which is anyone can pop up and say, "Oh, well, there was a deathbed donation." Suddenly those formalities get undermined. So what is the sort of protection that's involved? It goes way back. And what it's known as is the parting of dominion with the thing, the giving up the item itself or the means of accessing or controlling it. So in the case I just gave you of the ring on the deathbed, you can physically hand over the ring. But for some things that might be more difficult to do. Maybe it's not physically in your possession. Maybe it's a larger physical object. Cases slowly evolved to recognise that you could give sort of symbols of the thing. So if the ring was in a safe, you might give a key to the safe, and that would be recognised as sufficient because once someone has the key, they can go and open the safe, they can access the ring, the donee has control of that thing, the dominion has been parted with. Now that's easy to understand for chattels. What about bundles of rights? How do you hand over an ethereal legal concept, particularly if you consider rights in property, freehold title, leasehold title? It was an outstanding question of whether these could be given away via deathbed gift at all, and that was answered in Senate Headley, which is up on the slide there, which says that it is sufficient to give away the indicia of title. So something which is tantamount to sort of final proof and evidence of the title. Now, in the case of property, for unregistered land, that's the title deeds. Got title deeds, got the land. Simple as giving that away. That is sufficient to part with dominion. But this left an unresolved question about what happens with registered land, because their title deeds don't have the same property. It's the register that's conclusive. You can't give away a register on the deathbed. So it had been a view in the field that perhaps this was simply an end to a fairly niche exception to the Wills Act. Maybe it was just the case that deathbed gifts couldn't apply to registered land. here, we found that actually they can do. So in this case, the deceased had land certificates. Land certificates aren't around anymore, but they used to be provided by the land registry, and it was necessary to present the land certificate in order to get a change made to the register. So they were sort of quasi-equivalent to title deeds for registered land. Now, although the land certificate no longer had its historic effect, in this particular case, the court considered that it was a sufficient indicia of the title that handing it over was equivalent to handing over dominion. But even more significantly, and although obiter, the court noted that for those titles where there is no land certificate, so most modern registered titles, it would be very unsatisfactory if unregistered land and registered land over a certain age could be deathbed gifts, but registered land of a more recent age couldn't be. It would be sufficient to hand over an object that demonstrates the intention to make the gift. And that could be simply an office copy entry of the register. Now, this is controversial because an office copy entry of the register has nowhere near the power or evidence of title that a title deed has, and that a land certificate might once have had. So suddenly you're beginning to slip round the safeguards that say you've got to be really careful about going around the Wills Act. We really need this parting of dominion. We need this very clear evincing of the attempt to give away an object forever and for good to this other person. Instead, you're giving away an office copy of the register, which has no real power in and of itself. So this case is currently subject to appeal for that very reason. It's going to be a very interesting one to keep an eye on, because the decision one way or the other could either ensure that deathbed gifts have a long legal future ahead of them, or potentially it could be the end of the road for them. So that is all of the cases that we have for you today. If you stay tuned to our social media channels, you'll see that we'll be advertising the junior practitioner program for the rest of the year very shortly. So you can see the dates to turn up, who's presenting and what the topics will be. So keep your eyes open. Thank you very much for listening to us. That's me out, and Olivia as well.
Yeah, thank you for joining us.